In the know.
Good evening, everyone.
In the know.
Tony Reeves, fire. Following the news in any way, shape, or form. No shortage of things to talk about. What does it mean? What will it bring? Is this a reality we simply have to accept? Tony Reeves, fire. Tony Reeves, let's go ahead and
Welcome to another edition of Q&A Social Security Disability Today. I am your host, Attorney Anthony Reeves. Let's make it do what it do. All right. Again, this is part 7 of our 14-part step-by-step guide to understanding your disability hearing notice. Part 7, your right to request a subpoena. Okay. If there are some documents or a person that you believe needs to be there, you have a right to ask the court in advance to subpoena someone. But you need to make sure that you let Social Security know well in advance. So there is a subpoena right. Social Security does, the judges do have subpoena power in terms of asking for certain documents or certain persons and things like that. But you want to make sure that you do it well in advance. What do you mean by well in advance? Well, when you're trying to get all the medical evidence, or maybe you want to get somebody to testify, I cannot stress enough. You don't want to wait until like 4 or 5 days before the hearing and say, oh, let me see if I can get them to do it. You want to give the court an ample amount of time to be able to request the information that you're needing and sending out a subpoena so that this way the persons can respond accordingly. The more time you give, the better. So you want to do it as early as you possibly can. Some people are saying, well, how early is early? Well, this is what I would tell you. If you get your hearing notice and it says you can send in a request for a subpoena, do it right there and then. And you're like, how do you do it? Just ask. Just say a letter. I'd like for you to subpoena this particular individual for these records or for them to testify. Don't go anywhere. When we get back, we'll talk a little bit about what the subpoena needs to address.
Under the Social Security regulations, representatives are permitted to practice before the administrative agency anywhere in the country, which means that when you're looking for a representative, you can find someone who doesn't necessarily have to be in your state if you're just going before the administrative agency. So it's possible to have an attorney or representative who's from Utah, even though you may be in Georgia. And our office is actually no different. So if you're wondering which states we cover, check this out. Now, the tricky part is once you have to sue the Social Security Administration. Under that situation, you want to have an attorney that's representing you in your jurisdiction. So if you have a representative who's in another state and you've gone all the way to the appeals council and you've been denied and you want to sue the Social Security Administration, you make sure you ask that representative whether or not they can sue someone in that particular state.
All right, everyone. When you ask for the court to issue a subpoena, you need to be specific about what you need, okay? So what do you mean? Well, if you know you want a doctor to testify, and I congratulate if you can get a doctor to come in, because sometimes those docs won't. You need to be able to tell the court who's the doctor, address, phone number, what are they treating you for, and why it's relevant for them to be there. If there's medical records that you need, let's say that you have a doctor's office that's not being very cooperative and is trying to charge you some crazy dollar amount. You say, such and such a clinic on 53rd Boulevard, and all the way live, out in America, and this is their phone number. I've been treating them for a year. I go twice a week, and they've been providing me this treatment for this. They won't provide the medical records here, despite my best effort, or they're trying to charge me $600 and I can't afford it. Could you please subpoena those records? You want to be as specific as possible. But let me throw this out here so that I can make this point abundantly clear. Social Security has the discretion to say yes and the discretion to say no. So I don't want you to get all torn up a knot when you find yourself asking for this and they don't respond back as quickly as you like. I cannot stress this enough. They have the discretion to say yes or no. The court can say no, we're not going to do it. So I don't want you to sit here thinking that because you asked for it, they're going to make it happen. the court still has final discretion about whether or not they're going to request those documents via subpoena. But ask early, so if you need to make other accommodations, you can do so accordingly. That's it for us today. And tomorrow, as a part of our 14-part series, we're at part 8, where we're going to talk about what happens at your hearing. So stay tuned and look forward to seeing you tomorrow.
I want to thank all of you for engaging in the videos. Make sure you take the opportunity to send me any comments or send me any particular questions that you want me to have addressed here. As you know, this show is for you. And so the only way I can make sure that I can provide you some good information is if you provide me some good questions. Keep them coming, and right here on Q&A, Social Security Disability Today.